Hey, how you doing? Welcome to Checkmate the Matrix. So this is the third video in the series talking about the SAR, Subject Access Request. And this is how to deal with debts and debt collection agencies. So we're talking now about unsecured debt. We're not talking about like bills or unpaid bills, utilities or anything like that. We're talking about credit cards and bank loans. So, we're just talking about people who've got themselves into a predicament they can't afford to pay and they're ending up in debt collectors. Rather than panicking, we've got different ways of dealing with it. But this way, okay, what we want to talk about is how you can defend any claims and then actually turn it into an attack to put the debt collectors on the back foot and then to actually get a hold of them in court and beat them. So it's all to do with GDPR. Okay, it's in the Data Protection Act 2018. It's all about data, your data. Remember, you've heard that term before, data is the new gold. They are dealing with your data when they should not be, but also because what they're doing is making a claim. They're alleging that they have something. They've said to you when they send you your notice of assignment, just bear in mind the words that they're using. They love to use the word assignment, but that's just a notice of assignment. Literally, that's a letter from Fred, all right, sending it over to somebody else, going, hey, you owe me money now. That's it. That's all it is. That's nothing. What we're talking about is the deed of assignment. Now, I'm still seeing people getting confused and trying to put up arguments. Listen, we are talking about the GDPR. I'm going to go over it in depth here, why we use it and what we use it for. So, under the Law of Property Act 1989 miscellaneous provisions, then that states that they have to have a legally executed deed of assignment, which means that it must be signed by both parties, then also witnessed correctly at the same time. That's what they have to do. But we're not saying anything else about the Law of Property Act 1989 miscellaneous provisions or the Law of Property Act 1925, Section 136, but which states that there needs to be a deed of assignment, but it needs to be a legally executed deed of assignment. Okay, bear that in mind. But your data is the important part. This is our argument, if you want to call. Well, it is an argument because we're dealing in the legal side here. We're not trying to be like stand outside and be in the lawful, right? They are using the legal side of it, so are we to defend. It's very, very simple. Now, we just seen the video. We went live there with Richie and he showed how he had done the same thing using the words legally executed deed of assignment. It's what they do not have. This is the important part. So I've showed you the first one, the SAR, right? Well, I'm going to actually put them all in here. The first one, the SAR, subject access request. You're the subject and you're wanting to request access to all data that they have on you. So why would you do that? Why would you ask for the data? What difference does it make if it's going to prove a debt? This is the whole point. We are not arguing about the debt. We're not arguing about the law. We're not arguing about the jurisdiction. We're not arguing about the venue. We are arguing about our data. They have said that they've got our data. So let's say that you've got, and there's a few groups like on Friday, we had Richie on there. And he was showing that they had actually tried to take him to court, the PRA group, saying, we have a deed of assignment. And what they sent it through, and it was blank. Same as the ones that we've had before. They're blank. They've got nothing on. That is not a legally executed deed of assignment. You try going and telling someone that you own this house or a house, all right, and they say, well, there's the deed, and it's blank. You're not going to be in the house very long. It's absolutely insane. But this is what they try and do. And they send you the deed of assignment, saying, yeah, well, we've sent you it. There it is, right? So make sure your words are correct. We need to see a legally executed deed of assignment. Why do we need to see it? Because they've claimed they've got one. Now, if they say they have data on you, which they've just said, they must, under GDPR, and I'm going to read it out to you, and I'm going to share the screen so I can read it to you properly. It'll show you. They must show you the data that they've said. This is the Achilles heel. This is the weak point. So we're not talking about the Law of Property Act. We're not going to fight them with that. I'm not going to fight them with the Companies Act 2006. I'm not going to do anything like that. I know that there are backups on there. We're not saying in the Law of Property Act 1989 or 1925 that it says they need to show us. But in the GDPR, it definitely does say they need to show us any data that they hold on us. That's the point we're making here. So we're not attacking them on the Law of Property Act. We're not attacking them saying we didn't owe the debt. We're not saying prove the debt existed. We're not saying did the bank have a promissory note? You didn't lend us money. You haven't got a contract. Forget it. Forget it. We know all that anyway. Concentrate. Be laser focused. Go at them and attack them on this one thing. The GDPR and DPA 2018. They must show you the data that they hold. Now they've said, right, they sent you a notice of assignment saying we have purchased your debt. You now owe us. You will deal with us. Well, if they've said that, that's a claim. And what they're claiming is they purchased the debt. Therefore, they must have a receipt for that purchase. Everyone gets a receipt. Even at the supermarket, you get a receipt. You go into a restaurant, you get a receipt. You buy some clothes, you get a receipt, right? They have purchased your debt, allegedly. So what they must do is have a receipt, which is called the deed of assignment. But it needs to be legally executed. The same thing, you go and do like a transfer of a property on the land registry. You have to legally execute the deed. And it has to be written on. This is executed as a deed by... Then there's the full name and address. Then you have to sign it in the presence of. Then they have to put their name and address down and sign it. That is a legally executed deed, right, for the land registry. Well, it's the same thing when they're going to be purchasing this debt. They need to have it legally executed as a deed. This is the point. So if they've said they purchased it, then what they've done inadvertently is claim that they have this deed of assignment, well, they don't say legally executed, but that's what we're going to use. So on the SER, what we're doing, I've seen these like what you call them DSARs, subject access requests, whatever it is there, massive amount of questions on, show me this, show me this, show me this, show me this. It's not going to get answered, and it's not, and you're wasting your own time. Stick to very basic questions. We've shown you the others. I'm going to show you now number 3, the letter before claim. But we're also going to attach in the description, I'll put the other SERs. If you haven't watched the other videos, go back and watch one. Shows you how to do the first SAR. Second one shows you how to do the second SER as a reminder. And also, look, we're telling the ICO, we're going to make a complaint now to the ICO, Information Commissioner's Office, because you've breached data. So you make that complaint no matter what. I know they're not going to do anything, but you've got to get your paperwork in line. Now we're doing number 3, which is the letter before claim, which we're going to read out there and we're going to attach. Everything, remember again, it's all got to be sent with first class signed for the Royal Mail or recorded delivery, whichever one you want to do it, but there must be a record of them, you posting it and them receiving it and signing for it. So they can't deny it was there. Okay, this is the whole point. So what we'll do now, I'm going to explain and I'm going to read it out to you, the extracts from. Now you can go and check this yourself, but it's under GDPR. I'll share the screen and I'll read it out. This is straight off the government's website. There. So hopefully that's going to be big enough for you. So I'll just read it out there. So it's Article 15 of the General Data Protection Regulation, GDPR, outlines the right of individuals to access their personal data. This article specifies that individuals have the right to obtain confirmation from the data controller, the corporation, the debt collection agency in this case, as to whether or not personal data concerning them is being processed, and if so, to access that personal data and receive certain information about how it is being processed. Here is the relevant excerpt from Article 15 of the GDPR. 1. The data subject shall have the right to obtain from the controller confirmation as to whether or not personal data concerning him or her are being processed, and where that is the case, access to the personal data and the following information. You then state that you require to see in Part 1, Article 15 GDPR, after stating the individuals have the right to obtain confirmation as to whether or not personal data concerning them is being processed, it goes on to specify that if personal data is being processed, the individual has the right to access the personal data and receive certain information about how it is being processed. The following information referred to in Article 15 includes details such as 1. The purposes of the processing, 2. The categories of personal data processed, 3. The recipients or categories of recipients to whom the personal data has been or will be disclosed, 4. The envisaged period for which the personal data will be stored or the criteria used to determine that period, The existence of the right to request rectification or erasure of personal data or restriction of processing of personal data concerning the data subject or to object to such processing. 6, the right to lodge a complaint with the supervisory authority. 7, whether the personal data is not collected from the data subject, any available information as to its source. Therefore, when exercising your right under Article 15 GDPR, you can request specific information regarding how your personal data is being processed and handled by the data controller. That's the collection agency. The requirement to send a letter before claim is outlined in the practice direction on pre-action conduct and protocols. This is what we're going to send now. We've sent our first SCR. We've sent a repeat second SCR. We've complained to the ICO now under the pre-action protocols, which is the rules of court. We are sending the letter before claim. Specifically in paragraph 7, the practice direction sets out the pre-action protocols that parties should follow before commencing proceeding in the civil courts. Paragraph 7 states that before starting proceedings, the claimant should generally send a letter before claim to the potential defendant unless there are exceptional circumstances that justify not doing so. The letter should include certain information specified in the relevant pre-action protocol applicable to the type of claim being made. This is what we're going to show you now. It's important to consult the specific pre-action protocol relevant to the type of claim to ensure the compliance with the requirements for sending a letter before claim. Different types of claims may have specific requirements and timelines for the pre-action process. In a letter before claim, a breach of data protection, you should include the following information. Details of the claimant, provide your full name, address, and contact information. Details of the defendant, include the name and address of the individual organization you are accusing of breaching data protection laws. Summary of the alleged breach. Clearly outline the nature of the breach, including the specific data or information that was allegedly concealed or mishandled by the defendant. Concealed. Okay, because what they're doing, if they are not showing you the legally executed deed of assignment, then they must be concealing it because they said they had it. This is the point we are making. Number 4, legal basis. Explain the legal basis for your claim, citing relevant legislation such as the General Data Protection Regulation, GDPR, or the Data Protection Act 2018. Impact. Describe the impact that the breach has had on you, including any financial losses, emotional stress, or reputational harm. Well, we're going in for emotional distress and also the inconvenience and the financial loss because we had to do all the mailing and we took time out of our life. Demand for compliance. Clearly state your demand for compliance with the data protection laws, including the disclosure of the concealed data and any other remedial actions you are seeking. Deadline. Specify a reasonable deadline by which you expect a response from the defendant. This allows them time to investigate and claim and respond appropriately. Remember, we've sent an SCR and a second SCR, so we don't need to give them a month or anything like that. You can give them 7 days, and that would be perfect. And then it would be like it's a reasonable time, as they're saying there. Okay, specify a reasonable deadline. All right, so that would be perfectly reasonable. Threat of legal action. Clearly state that if the defendant fails to comply with your demands with the specified time frame, that you will commence legal proceedings against them. Request for confirmation. Request that the defendant acknowledges receipt of the letter and confirms whether they intend to comply with your demands. Enclosures, if applicable, include copies of any relevant documents or evidence to support your claim. It is essential to ensure that your letter before claim is clear, concise, and legally sound. That's why we're going to go over the letter before claim with you now. So that is coming straight out of the actual government's website and all of the regulations. Now that states clearly that you have the right to send the SAR and that you have the right to see and know how they are processing the data. Now, they've alleged that they've purchased your debt. They've sent you what they call a notice of assignment. But what they're not doing is they're not showing you any data. So when you request the data and you say, I want to see this legally executed deed of assignment, don't ask for anything ridiculous. Don't try and approve the debt, blah, 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 conditional acceptance, anything like that. You're sticking with GDPR, DPA 2018. You want to see the data. They've said they have it. So they have to have a legally executed deed of assignment. They must have that under the Law of Property Act. right? And it has to be signed correctly under the Law of Property Act 1989, the miscellaneous provisions. So we're presuming that they must have it then if they're saying that they purchased it. So fine, not a problem. Just show me all of my data, including that. And it's said under there, I've just read it out to you. That's not me making it up. That is in the guidelines. And it says under GDPR Article 15, they have to show you the specific things you request. So we're not asking them for blood. We're not asking them to like do anything ridiculous. We're asking them for the paperwork that they've alleged that they have. So now what we'll do is we'll show you the letter before claim. See how small, how exact and precise it is. You don't need to give anybody war and peace. You don't need to try and convince them that there's 17,425 and a half acts that they've broken or breached or anything. We are laser focused on the GDPR, DPA 2018. They are breaching our data by concealing what they have said that they had. Straightforward as that. Yes, it comes under the Law of Property Act 1989, the miscellaneous provisions, how they need to legally execute that. But it doesn't say there that they have to show us it, but it does under the GDPR. That's all there is to it. And they haven't got one because they never buy the debt. We've just done it again. We showed you the live video. They bought block data. So when it come to the court, when they were taking Richie to court, they didn't turn up and they didn't pay the fee and they didn't provide the evidence because they haven't got it. So, right, so there's the proof of it. Again, if they are trying to take you to court, they can't. But they will go right to the wire just to scare you to make you pay. They're going to scare you and make you so fearful, think, oh, I'm going to court, don't want to do that, oh, and you're going to make an arrangement to pay. And they haven't got any evidence because they buy block data. They do not buy the debts, not like that, not legally, and they haven't got a legally executed deed of assignment. So we send them the next part, number 3, which is the letter before claim. Let's have a look. So again, we have the letter before claim. We have our address over on the right-hand side of the creator, or you might say the right-hand side of God, whatever you feel. On the left-hand side, we have them. We have the debt collection agency. Okay, so we're going to tell them what it is, what we're talking about. It's a letter before claim. We're going to put the date in. We're going to put the alleged account number in. To Fred Jones, Director of Jones Debt Recovery Limited. There's the date, alleged account number, subject, letter before claim, breach of data protection laws. We are being very concise with it, aren't we? I am writing to you regarding your refusal to comply with my repeated request for the disclosure of data pursuant to the General Data Protection Regulation, GDPR, and the Data Protection Act 2018. Specifically, I am seeking access to a legally executed deed of assignment in relation to the alleged debt reference blah blah. As a data subject, I am entitled to access any personal data that you hold about me, including information related to the alleged debt. Despite multiple requests made under the GDPR and Data Protection Act 2018, you have failed to provide this crucial documentation. Your refusal to disclose the requested information constitutes a serious breach of data protection laws and undermines my rights as a data subject. It is imperative that you comply with your legal obligations and provide me with access to the data that you hold about me. Therefore, I demand that you provide me a copy of the legally executed deed of assignment pertaining to the alleged debt within 7 days from the date of this letter. Failure to do so will leave me with no choice but to commence legal proceedings against you for breach of data protection laws. Please be advised that I have taken legal advice on this matter and I am fully prepared to pursue all available remedies to protect my data rights and hold you accountable for your actions. I trust that you will take this matter seriously and act promptly to resolve it in a satisfactory manner. If you have any questions or require further information, please do not hesitate to contact me using the details provided above. All rights reserved. So there you have it. That is your letter before claim. It's very clear. It's very precise. You tell them exactly what you want. So you're following on from the first SER when you're asking for the legally executed deed of assignment, a couple of other things to fill it up, but it's only a few questions, right? Then we've repeated the same questions again when we said you haven't replied with compliance. That's the SEL2. We're going to report you to the ICO if you don't give us that data properly in 7 days and comply. Again, we make sure we do the complaint. I've showed you on the second video how to do the complaint as well as the actual second SAR. So this one here is the letter before claim. There it is. So we have to send this again. It's going to be sent out there. It's going to be signed for and everything. So you have proof. And this is your line of attack for when we actually going to file a claim. So the next time what we're going to do is we're going to actually do an intent to prosecute. So it's another notice giving them a way out, saying, look, settle now, all right, or we are going to file this in the court. And then, we're going to go 50% of what we're going to actually go for the damages, for the distress caused and the inconvenience of dealing with this process, dealing with this situation. Recap over it. We're going to do the first SCR, the second SCR, and the ICO warning, then the ICO complaint. Right up to now, we've given them 7 days to do it. Now we're actually giving them the letter before claim. We're sending this letter before claim. We give them 7 days, and then we are actually going to send the intent to prosecute and file the N1 a week after that as well, 7 days after that as well. So in the description is going to be the links. You can actually download it there. It's all done for you. Okay, so you've got it in templates so you can do it. And we showed you that as well, didn't we? All right, the banks themselves have got those templates that they use. and then they just tell us we're all stupid for using templates. But this is legal. We've actually got this checked out. So this is what we're doing is 100% legal. They can't say it's a template. This is a legal requirement. Have a look at the description, download your own documents. Make sure that you like, share, and subscribe to the channel as well. And make a comment, leave a comment as well if you like. See you in the next one.